So when they're coming back to the United States, if you already have a green card, you are not seeking admission into the United States. So you've already been admitted to lawful permanent residence, okay? Port of entry officer generally is not admitting you, just allowing you to come back. And typically they will let you in, unless, like I said, you've committed a crime abroad. And if they have reason to doubt whether or not your green card was properly issued, then the government have the right to put you in removal proceedings, that is, put you in court for deportation.
5 years visa. Coming in, I spent 5 or 4 months. I've gone back to Nigeria. I'm trying to come back and I've been denied entry. You gave me 5 years multiple visa.
Right.
When I came, you stamped in for me 6 months to stay in the country. I stayed for 4 months. I've gone back. I've gone back for about 7, 8 to 1 year. I'm coming back and you are stopping me from coming in. Are you not infringing on my right?
I just want to remind your viewers that nobody have a right to enter the United States. It is at the discretion of the United States government. The truth is, and this is my view, basically they are trying to reduce the number of people they will give a green card to. That's just the truth.
What is blowing in the air? I've heard now, if your spouse filed for you in US, go back home and wait for the response from USCIS. There are a lot of conversation. What is really happening? Can you talk to us? All right, ladies and gentlemen, it's a beautiful time here, and I'm about to have a very beautiful, noble conversation with Mr. Emmanuel Aseriwa. He is a lawyer, immigration lawyer for that matter, and there has been a lot of fear in various homes, various churches, various working environment, and various marketplaces, and people are talking both here in America and people back home, because people back home are scared for their relatives, their friends, their husbands, their boyfriends, their girlfriends, their wives, who are one or two ways not done with their immigration processes. Some are just here for visit. They've met their partners and they want to marry them for real. But there has been a lot of changes in the immigration system right now, and as a matter of fact, there is fear in the air. So Mr. Emmanuel Aseriwa is a lawyer, immigration lawyer for that matter. He has been able to help many to smile through the immigration processes. Today he's here and he's about to talk to us, have a conversation with us. Do we have to fear? What is this new Trump administration with immigration? As a matter of fact, if I am filing for green card, do I have to hold on right now? Do I still have to proceed and go ahead and file my immigration status? What is the change? Am I well to be in America? Do I even have to come to America for now, or I have to hold on? In the meantime, I am naive, as you are. So he is the one we have invited here today to come and have a conversation with us and to see as to whether it is well to go ahead and file for your green card or your citizenship. Mr. Emmanuel, welcome to COS TV.
Thank you very much.
I appreciate your time so much. Thank you. Appreciate you so much.
Thank you for having me.
Who is Mr. Emmanuel Aseriwa?
Well, just like you rightly mentioned, I am a U.S. immigration lawyer, but I always like to start by letting people I represent and people who come to me for help that I am an immigrant myself.
Okay.
I'm originally from Nigeria,
okay.
And I represent American citizens, companies who are petitioning for family members, employees to get green card, become U.S. citizens. I also represent people who are facing deportation in immigration court.
Okay.
And my law firm has helped more than 2,000 people with their immigration cases, particularly a vast majority of them being Africans, Ghanaians, Nigerians, people from Liberia, all parts of the world.
Okay, okay. Now, with that being said, you rightly said you've helped a lot.
Right.
Over 2,000 people to smile in their various homes.
Right.
How is the process like? Like, let's say I have my visa to come to America as a visitor, and I'm here. I don't want to go back home. What can I do to stay?
Well, there's several routes to lawful permanent residence in Nigeria. In the United States, I beg your pardon. There's several pathways to lawful permanent residence in the United States, and each one of this pathway is provided for in the U.S. Immigration and Nationality Act. So the popular one is green card through family base, which is where a U.S. citizen marries a foreign national. Say somebody coming from Ghana here in the United States, they get married to a U.S. citizen. The U.S. citizen is eligible under the law to file a petition on behalf of that foreign national, that Ghanaian or that Nigerian who is here in the United States. Or you are a U.S. citizen and you have a child who is abroad, you can also petition for them. Or you have a fiancé, two of you are not married yet, but the two of you love each other and have agreed to be married, you can also petition for them. If you have a company, certain companies are eligible to file a petition for a foreign national spouse, a foreign national employee, and they can bring that employee to the United States. But here's the deal. There's two parts to it. The U.S. citizen who is petitioning for that beneficiary has to meet certain requirements, and we're going to talk specifically. But that person who is applying to get a green card also do have to meet certain eligibility requirement. And here's the big news that is going on is about whether or not you can come to America. While you're in America, can you file a green card? And there are processes provided for adjustment of status under Section 245. But yes, there's a latent process under U.S. immigration law which can get very complicated, and especially under the Trump administration, the government has made so many policies that has made it much more difficult. But the point is, the laws have not changed. None of these laws have changed, but policy and the enforcement procedures we have seen all across the United States have really changed in recent times.
So with that being said, if I'm going back to what you said, so through marriage I can get my green card.
Correct.
What are some of the requirements that my spouse, my fiancé, my husband-to-be need to meet before I will be able to petition for him or her?
All right. So the first thing I like to advise your viewers is that there is no automatic green card because you are married to a U.S. citizen. It is just the first step to be married. Now, after getting married to the U.S. citizen, you and that U.S. citizen spouse have to show with evidence that your marriage is valid under the law. So firstly, that marriage must have been entered in good faith and legally valid, which means you cannot be married to somebody in Ghana and come here and get married to another person who is a U.S. citizen without firstly terminating that marriage under the law. So that means you must first of all have a divorce. That marriage must be legally terminated either through a divorce or by death. So you have to prove that the two of you at the time of entering the marriage, you or the U.S. citizen must be legally capable to enter into that marriage. And that's one. Now your intent of entering into that marriage must also be genuine. It must not be this marriage is for green card only. And we're going to talk more about that. Now, having shown that your marriage is valid, you also have to show that that marriage is bona fide. What is bona fide? It means that the marriage is genuine, that the couple are living together, that they are having a shared life together, and that they're commingling their resources, things like showing that the two of you live in the same residence. And you can do that with your lease agreement, or you can do that with your driver's license, or you have a mortgage together. You're showing that if you have children in the marriage, you have to provide evidence of the birth certificate showing that those children are born to both of you in that marriage. You also have to show evidence such as support statement from people who know about your marriage. You have to show evidence that the two of you are commingling your resources. For instance, you have a joint bank account together, or you have a credit card together. All of these are what we call in immigration law bona fides, to show that husband and wife are living together as they should. Now, it is critical to mention that what immigration expects to see sometimes is not what happens in a real life marriage. Now, there are so many husbands and wives who do not have bank accounts together because people don't want to put their money together. Money is always a big issue in every marriage. But when it comes to immigration, there's certain evidence that the law has provided for through case law. The BRA, the Board of Immigration Appeals, have had in so many cases, the several types of evidence that you have to show that your marriage is bona fide. There is no one single type of evidence, and you do not have to provide all of this.
Okay. Now I have really understand you. Somebody may have all these qualifications you just mentioned, yet
Right.
they will go for the interviews and they will be denied.
Right.
Why?
Now, recently, particularly on May 21st, 2026, USCIS came up with a policy memo, which has to do with the adjustment of status. Basically, USCIS was saying in that policy memo that getting a green card is not automatic and it is not a right. It is an exercise of favorable discretion by the government. That is the law, stricto sensu, that is the law. What that means is that you can have all the requirement, but the government still has to exercise discretion. So the immigration officer acting on behalf of the Secretary of Homeland Security have to exercise what is called favorable discretion. What that means is that, yes, I see that you have all the requirements under the law, but this is my house. I still have to let you in. That is what is called exercise of favorable discretion. And what USCIS is reminding their officers in this memo, a lot of people are talking about the memo. The memo is not a law. It is not changing any law.
Okay.
It is just reminding adjudicators, that is the officers who will conduct those interviews and make the decision, that, hey, the fact that this gentleman has all these documents, is married to a U.S. citizen, is not by itself conclusive that you must give him a green card. You have to look at his immigration history. When did he enter the United States? Since he came to the United States, has he committed any crime? If he committed a crime, under what circumstance? Before he came to the United States, what did he tell the consular officer when he was applying for a visa? If he told the consular officer that he was never married before, and then he comes here, he's filing his application, he's saying he had a spouse before, or conversely on the other side, some people go for interview and say, I am married, I have 2 children. Because in order for you to get a visa to America, it is important to show that you have strong ties to your country. So how do you show strong ties? You have a wife, you have a child, or you have a good job, you have a good business in your country. The popular one we have seen in many cases, and sadly in many countries in certain parts of the world, particularly countries in Africa and Central America, where there's a huge searchlight on marriage fraud, is that certain people claim that they have a spouse or a child. Now, when they're applying for a green card, they sometimes forget what they said when they were applying for a visa.
Okay.
And now they're telling the truth that I have never been married before, I have no child. And then the immigration officer has access to those records when you applied for a visa. And then they look at it and say that, oh, this is not what you told us when you applied for a visa. That can mess up the entire process. And under U.S. immigration law, that can render a person, even though they are married to a U.S. citizen, they have children together, everything looks good about the marriage. The government is not questioning the marriage now. The government is questioning your admissibility. What is admissibility? It means that your qualification under the law to get a green card. So if you've provided false information, or there are cases where people have provided false documents, things like bank statement or divorce document, the government can exercise that discretion and say, if you could lie for during your visa, despite the fact that your marriage is good, you have children together, you live together, everything is fine, we can exercise our discretion not to give you that green card because of your immigration history.
So, wow, meaning that back home, Ghana, Nigeria, Cameroon, Kenya, wherever you may be coming from,
right,
when you are going to see the counselor for your visa,
right,
that time you should be able to give accurate information. Right. Everything you are providing at that time should be accurate and legit, no lie.
I mean, I would say that generally speaking, throughout the immigration process, one mistake a lot of people make is providing false information or document. That's a no-no. And people do this because they lack the right information. They're not speaking to experienced immigration lawyers because there are loopholes under the law that you don't necessarily have to lie. You can still qualify for that benefit by providing truthful information, and the government exercise favorable discretion.
Okay. Wow. This one is reminding me of a friend of mine who traveled to US, went back home and coming again, and the immigration did not allow him to come inside. They sent him back home.
Yes.
What could that be the cause?
So I have represented thousands of people with immigration cases, and I've seen virtually everything. Recently, a lady came to us who has a child who is from Nigeria. The child is a U.S. citizen, and child petitioned for the mother. And immigration gave the mother a work authorization. They gave her an advanced parole. What that means is she can travel abroad and come back.
Okay.
She traveled abroad, came back, and a couple of months later, they put her in deportation. Just like your friend, the immigration officer can choose not to allow a non-immigrant to enter the United States. So getting a visa is not automatic that you'll be allowed into the country. The CBP officer, that is a Custom and Border Patrol officer at the port of entry, typically in an airport, still has to go through your record and exercise that discretion to allow you to enter. Now, in the case of that, your friend, there are several things that could have happened. More than likely, he does not have a green card yet. If a person has a green card, by all means, they are allowed to enter the United States unless they committed a serious crime after leaving the United States. So when they're coming back to the United States, if you already have a green card, you are not seeking admission into the United States. So you've already been admitted to lawful permanent residence. Okay. So the port of entry officer generally is not admitting you, just allowing you to come back, and typically they will let you in unless, like I said, you've committed a crime abroad. And if they have reason to doubt whether or not your green card was properly issued, then the government have the right to put you in removal proceedings, that is, put you in court for deportation. But generally speaking, unless you voluntarily relinquish your green card, which I have seen that happen many times, because I had a case of a guy who was coming to the United States, and the immigration officer found out that he lied when he entered into that marriage. And the immigration officer told him, we're going to detain you, which they have the right under the law, even though you have a green card, we're going to detain you and put you in deportation. But the gentleman is a big shot in Africa and did not want that to go into the public domain. And so he signed a form that is called the Form 407, which allows a green card holder to relinquish their green card and go back home as though nothing happened or as though he never showed up.
Oh. So meaning he's giving in the...
So he gave up his lawful permanent residence in the United States, just because he did not want to go through that process.
Can he fight back?
At that point, not. But if he had caught someone like me with experience in defending people in immigration court, I would have told him, come in and we're going to deal with it in court, because there's so many relief you can seek when you're facing deportation in immigration court. But a lot of people, like I said before, one of the biggest mistakes that a lot of people make is lack of legal representation, legal advice. Just like the green card memo that everyone is talking about now, you know, just talking to you and your viewers, you now understand that it is not a new law. It does not necessarily change anything. The only thing it does is reminding adjudicators, that is USCIS officers, that they have a power to deny a green card to a person, even if the person meets the eligibility requirement. So the memo, if you have the chance to read the memo, you'll see that particularly in the last page of the memo, USCIS is telling their officers, now you have to look at things like family ties. So if a person is applying for a green card, you have to consider several favorable factors as against the negative factors.
Hold on to that one. We will come there. We are building the point. We will definitely come there. It's been a beautiful conversation with Attorney Emmanuel Asiriwa.
Thank you for having me. I appreciate it.
And let me go back to this visa, 5 years visa, coming in. I spent 5 or 4 months. I've gone back to Nigeria. I'm trying to come back and I've been denied entry. You gave me 5 years multiple visa.
Right.
When I came, you stamped in for me 6 months to stay in the country. I stayed for 4 months. I've gone back. I've gone back for about 7, 8 to 1 year. I'm coming back, and you are stopping me from coming in. Are you not infringing on my right?
That's interesting. I just want to remind your viewers that nobody have a right to enter the United States. It is at the discretion of the United States government.
Okay.
But you would expect that that right will be exercised in a judicious manner. What that means is you would expect that the government would, follow the law and on a case-by-case basis would exercise their authority with some human face.
Okay.
And what we're saying from the current administration is that they're pretty much saying we don't want some of you here. And that's why you see a person who has a 5-year visa coming to the country, they give them 6 months, 6 months on your I-94. It does not necessarily mean that you are supposed to stay for those 6 months. So what is happening, and we've seen this in many cases, is that when the person applied for a visa, they usually would ask you for a B1, B2 tourist visa. How long are you going to stay? What is the purpose of your trip? And you say, I am going for 30 days because I have a conference that will last for 2 weeks, or I'm going to visit my son or my family member, my business partner, and I will be there for 30 days. Now, you get the visa, you get to the port of entry. The port of entry officer sometimes would ask you similar question, if not exactly the same question. And a lot of people would answer the question the same. I am here for such and such purpose, which is usually for temporary purpose, and I will return back after 30 days, just like they told the consular officer abroad during the visa process. Now, typically, for non-immigrant visa entry, you get 6 months. That is the maximum the government issues. And in many situations, that is what they usually issue. It does not change the fact that you told them it was 30 days. After 30 days, you decided to say, oh, I want to stay more because at the very least, they gave me 6 months, which is under the law, you have not done anything wrong. You've not violated the terms of your visa because you were given 6 months. So long as you live before that 6 months, you have not overstayed your visa or your duration of stay, as it were. But keep in mind that you could be found inadmissible to the United States for lying and providing false information during your visa and during your entry. Why? At the time of your visa interview, you said, I was coming for this exact purpose for 30 days. You get to the port of entry, you ask the same question, you say, I am coming for that exact purpose for 30 days. And then you were given 6 months, which sometimes I would say that 6 months like a trap. and you decided to say, oh, that purpose no longer matters. I'm going to stay for 6 months, or I'm going to stay for 4 months. Even if you've not violated the terms and conditions of your non-immigrant visa by not accumulating a lawful presence, which means you did not overstay because you have 6 months, the government, in the next time you come back to apply for a visa, to renew that visa, or the next time you come back to the United States, they could look at that record, the record of your interview, the record of your entry, and what you actually did. And they could find that person to have violated Section 212, paragraph I, which is providing false information, material to the grant of your visa.
So, Attorney, then everything centers around your first counselor you met in Nigeria, in Ghana, the first interview you went. Everything begins from there.
Everything starts from the very first time that you apply for a visa.
Now, what if I came to US, I came to fall sick, I'm sick, and during the process, within the 1 month, I was very sick and I had to go to the hospital, I couldn't fly and all that. What if I provide doctors something from my medical doctor indicating that, oh, I was sick at this period, blah, 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 blah happened, that's why I couldn't go back?
Yes, that is correct. Okay. The law provides for that.
Okay.
If a person enters the United States and they are given a certain period to stay in the United States, if there are extenuating circumstances, that is to say, if something out of the blues happen, for a good example, if the person becomes seriously sick and they are admitted in the hospital, there's a pathway for them to extend their period of stay, and that is filing a form 539, which is an application to change or extend your duration of stay, your lawful non-immigrant status in the United States. So you can extend your time in the United States, and you would have to show evidence to USCIS. That application is filed here in the US. You have to show evidence that why you have to extend your stay.
Can that evidence, after providing all those evidences and all that, can they still deny?
Yes, the government can still deny that application to extend or change your status. They may approve it, and you could still go back abroad, apply to renew your visa in the future, and the consular officer over there still deny your visa because they consider that you overstayed your time, even in situations where you had an extension of stay. And it's because there's so much discretionary exercise of power when it comes to visa. There is no right to a visa. Everything hinges and centers on the exercise of discretion. But over time, decades in U.S. immigration, the exercise of that authority has never been stretched to the limit as what we're seeing today under the Trump administration, which is why it is highly recommended that people be careful throughout their immigration process and never treat the process of getting a visa or a green card or applying for naturalization as simply a form filling process, because that's what a lot of people thought that immigration is all about.
Some people actually just hire people to do the forms without even knowing what they put in there.
Well, I have seen in my practice, I've seen hundreds, if not thousands of such situations.
Okay.
Yes.
Now let's go to the main topic why we are here for this conversation. What is blowing in the air? I've heard now, if your spouse filed for you in US, go back home and wait for the response from USCIS. There are a lot of conversation. What is really happening? Can you talk to us?
So, just like I alluded before, on May 21st, 2026, which was just last week, USCIS came up with a memo that has to do with adjustment of status. Adjustment of status, in this memo, the topic of the memo is, just paraphrasing, adjustment of status is an exercise of administrative grace. And it is an extraordinary relief that is granted to a person in the United States as opposed to going through the ordinary process of consular processing. I'll break that down. I know that seems like a long stretch. But what the government is saying, what USCIS is saying now is that a person who enters the United States, generally speaking under Section 245 of the Immigration and Nationality Act, is allowed, as long as they enter into the United States, they are allowed to apply for adjustment of status if they become a beneficiary of an approved immigrant petition. Okay? Now, but the government is saying under this memo, under this policy, that we don't want you to be doing that anymore. If you marry a U.S. citizen, yes, your U.S. citizen spouse is allowed to file for you, but we want you to go back to your country, because when you first came, you said you were coming here for school, to go to school for 1 or 2 years, or you first said you were coming here for tourism or for a conference. You should not now be changing your intent. You should, even if you're married to a U.S. citizen, you should go back to your home country and apply for an immigrant visa. Why is that a big issue? Many of these persons may have been here for more than 6 months, which triggers a 3-year ban. Okay, say for instance you came here a year ago on a visa, a tourist visa, and you did not leave. You fell in love with your American wife, and now she's petitioning for you. If you leave the United States, based on what USCIS is trying to ask people to do, if you leave the United States after 6 months of being here, when your visa, your duration have expired, you are subject to a 3-year ban, which means that after, you must go out of the, if you go out of the United States, you must stay for 3 years before you can even come back in. Or if you're being here for more than a year, you're subject to the 10-year bar. So once you leave, if we were to go by what USCIS is saying, once you leave, you'll be separated from your U.S. citizen wife, and maybe you have a child with that spouse. That is tearing your family apart. But the law does allow you, under Section 245, not to leave at all, but to apply for a green card in the United States. However, USCIS is saying that that law also recognizes that it is at the discretion of the Secretary of Homeland Security, such power that the Secretary has generally delegated to USCIS officers. So USCIS is telling their officers that even if a person came here on a tourist visa, which they're allowed to do that, coming in tourist visa and apply to adjust their status, that is apply for a green card, that it is not enough anymore. The officers should look into that person's record, look through his address history, that is where has he lived before, where he currently lives with that spouse, has he committed any crime, has he been a person of good moral character, for instance, does he go to church, does he support people in his community, does he have good ties to the United States, does he have a wife, does he have children? So those are favorable factors that USCIS is reminding their officers that they must consider before giving somebody a green card. But the truth is, and this is my view, basically they are trying to reduce the number of people they will give a green card to. That's just the truth.
Okay, so does it mean it is already a law that was there many years ago, or it is Trump administration who has rekindled this law?
So this law, Section 245, is part of U.S. Immigration Nationality Act provision. The law, nothing new in what USCIS is saying. It has always been the practice of U.S. immigration. It's a long-standing U.S. immigration policy, and law, Section 245, provides for exercise of this favorable discretion or exercise of discretion by the government. So this policy from USCIS has not changed any law. Now USCIS is saying officers, my officers, USCIS now as the agency is telling their officers, remember you have a power under the law,
so it's just
to exercise your discretion.
Them.
Essentially they're reminding the officers of their powers, the discretionary powers to choose who to give a green card to or who not to give green card to. So they're not making new rules.
So now I'm asking, law. Do I have to go back home currently whilst I'm waiting for my green card process to be done, or I should still wait?
You don't have to go home. Okay. And here's what I would tell anyone listening. The law has not changed.
Okay.
The procedure for applying for a green card in the United States has not changed.
Okay.
But what has changed is the standard of review, how the officers are now critically looking at these cases, particularly cases coming from certain parts of the world. I'm not going to mention names, but we know that from certain parts of the world,
Africa.
Well, you said that, but in my experience, and I represent people from all over the world.
Okay.
When we have cases involving people from Africa, not just Africa, in Central America as well, the level of scrutiny of those cases, in my view and experience, and I'm talking about hundreds of cases, is different from when my client is from Australia or from Europe or from England. It is different, and anyone can challenge me on this, and it's something that I have seen. So I want to remind your viewers that you don't have to go back home as long as you came here lawfully, you came here on a visa. If you marry a U.S. citizen, or you have a parent who is a U.S. citizen and you're a child of that parent, or you are a parent and one of your children, 21 years and above, is a U.S. citizen, you don't have to go back home. What you have to do is to speak to an experienced immigration lawyer to review your case before filing. And one mistake a lot of people make is quickly jumping into the filing process without first preparing their case. Now, what is new about this memo, and again, it's not a new practice or it is not a new law, but what USCIS officers are now encouraged to do is to take a microscope when they look at these cases and to look front, back, right, and left. And that is where you need an experienced immigration lawyer to help you not only show that you are eligible, but show that you have enough evidence for the officers to exercise favorable discretion. If you do not remember everything we're saying, you should remember the exercise of favorable discretion. That is what this memo, in the longest short of this memo, is the exercise of the officer's discretion. And in order for you to show to the officer that they should exercise their discretion in your favor, on top of showing that you are eligible, now you have to show that you have ties to the United States, you have no negative factors such as you are not a criminal, you have long-standing history with the United States, you have never provided false information before, and so many other ways that you can show that you should be given that exercise of favorable discretion, including good moral character. And that is where it is important to hire an experienced immigration lawyer to help you frame this argument. And keep in mind, the Trump administration has made it compulsory for anyone applying for a green card in the United States to attend an interview. Before Trump came, the Biden administration and many administrations in the past have been able to approve a case, a green card case, without you showing up for interview. So for instance, you marry a U.S. citizen, the two of you have a child together, you have not committed a crime before. The officer can take a look at the totality of the circumstance, which is what this memo is also asking them to do, and say, this looks like a good case, and I approve it. Before Trump came this second time, we had hundreds of cases approved without going to interview. But once the Trump administration came on board, they changed that and said everyone must appear for interview, which they have the right to do. But when you go for those interviews, do not just jump in, wear your clothes and say, hey, my wife, let's go for an interview because we're married, everything is good. You need an experienced attorney to, in addition to preparing your case properly, to prepare you for that interview and follow you to that interview, sitting side by side with you. Because what we have seen in many cases is that the way the officers address or conduct the interviews when a lawyer is present is sometimes, in many cases, different when a lawyer is not present. Because when I'm there, I know the law. You can't railroad my client in my presence. I'm going to make the objection. I would not testify for the client because the questions are asked to my client, and they should provide the answer, which I had already prepared them before that interview. But if the officers start, violating the provisions of the law, which I have seen that happen in many cases, all the officers are applying a rule that is not, that I consider to be harsh to my client, I can make objection. And I've told clients in many interviews, do not answer that question. And you have a right not to answer.
What if he denies or she denies me what I'm looking for?
Well,
because I did not answer.
Well, I am not there to fight the officer. I am not there. I always try to make the interview friendly because, and many of the officers know me, because if the officer is happy, I am happy at the end of the day. But if the officer is asking you a question that will incriminate you, for me to tell my client not to answer, I already know that the answer to that question will probably damage the entire process. So I would not ask my client to answer something that I believe will help
in the process of the interview.
At the interview, I'm talking to you now. Just like you and I are talking. An interview is, say a meeting like this. The U.S. citizen is there. The spouse who is applying for green card is there. The immigration officer is there. And I am seated there with my client side by side. So the officer is asking them questions. And now what we're saying is that many of those questions would not just be the usual question about how you enter into this marriage, how you met your spouse, why you are married, do you live together. The questions beyond that are now going to question you who is asking for a green card, your credibility, your personality, your good moral character. Because at the end of the day, the officers need to look at to weigh the favorable factors against the negative factor in order to make their exercise of discretion conclusion.
Hey, immigration is not a joke.
It is complex, and the current administration is coming out with full force. And we know that they are targets, and targets, in my opinion, and the president did say it about a year ago that they want quality immigrants, citing people coming from Norway and other Europe countries. And what does that mean? It means that there are some immigrants that are not of quality, and you know what they mean with that.
How can I prove that my marriage is legit? How can I prove that I am of good behavior? Sometimes maybe I may go to the interview room and I'll be intimidated, not because I'm lying, but because somebody may go for interview for job or something like that, and as soon as you see
people are generally nervous.
Yeah, you see the 6 panel member sitting down, you are nervous.
Right.
Not because I'm lying. I'm actually nervous. What about that?
Well, the first way to prove that you are deserving of that green card through a marriage to a U.S. citizen is having your case properly prepared in the beginning. So when anyone comes to my office for they're married to a U.S. citizen, or some people even reach out to me before they get married, and I think that's the best thing to do. I do scrutinize every one case that I file like the immigration officer would. So I ask my clients questions that sometimes they're not comfortable with, but I can care less how you feel right now. I care where I take you to get you the green card. My job as a lawyer is to look at the loopholes of the law and find any possible red flags in your case and close those red flags, legally speaking. Properly preparing a case, you cannot afford right now to file a green card without having a lawyer. You just can't afford that. At this time, I think it's a foolish idea to do that, with due respect. Because the winning any case, and this is not just immigration. I've been a lawyer for about 18 years now. Winning any case has to do with preparing from the very beginning. It's like building a house. You don't just have a fine structure without having a good foundation. So the properly prepared green card application starts with hiring an experienced lawyer who looks at your circumstances, looks at the facts, review the evidence, question you, and get all the information they need and prepare a properly prepared packet. Now, if you see the average green card, particularly for marriage, now we're talking about marriage, if you come to my office and see the average application we file involves more than 200 pages of documents, evidence, and forms. And when an officer sees a properly prepared application, that is the start of how you win a case. Now, on top of that, we advise our clients on the things they should be doing to get their case going. And before they attend that interview, we sit down on several meetings, at very least 2 interview prep sections, like a mock interview, where we prepare our clients. We're not telling them what to say, but we're telling them what kind of questions they should be expecting, and they should go back home. Likely questions you should expect at an interview. We will go through all of that with you. We will go through every single page of the application we have filed. And if we need additional document, which in many cases, by the time you get to the interview, you would have gotten additional evidence, we would gather those evidence with you and ensure, including checking the criminal background of our clients, ensuring that there's no surprise during the interview.
Wow, ladies and gentlemen, it's been a wonderful conversation with Attorney Emmanuel Asiriwa.
Thank you.
And he is a very great man in Texas, United States. He's been practicing this for close to 20 years, 18 years and still counting, and has been able to help over 2,000 clients to succeed in their immigration status. Lawyer, we don't have to fear.
Not at all.
We don't have to go back home.
Not at all.
Do you think all this is happening because of the FIFA World Cup that is happening in US, or what do you think it has some influence in this?
Well, I don't know about that, but I think firstly I would say to anyone who is listening, there's no need to panic. Okay, do not panic. You need to be prepared and we're saying this including arrests by ICE that we're seeing everywhere. But do not panic. If you are married to a U.S. citizen and your marriage is legit, you do not have to go back home. You just have to prepare. You don't have to go back home. You don't have to be afraid. And I don't know if this is about the FIFA World Cup coming up, but we're certainly all looking forward to it. Unfortunately, Nigeria is not going to be
but Ghana is part of it, no?
Yeah, I'll be rooting for Ghana.
Of course,
for sure, I'll be rooting for Ghana, and already planning to watch some of the games that we played in Houston area,
yes,
in Dallas. Yes.
What if somebody's in the process of getting his or her citizenship? Does the person have to be in good shape or fear, or right now, what's up?
So, very good question, Christian. Virtually everything we have said when it comes to your immigration history, preparation, hiring a lawyer applies also to citizenship. As a matter of fact, I think that a lot of people, from my experience, make more mistakes with citizenship than they do with green card. Do you know why? Because when a person already have a green card, they think that it's game over. It is not. You're not out of the wood until you take that oath of allegiance and swear to become a U.S. citizen. In fact, right now we're saying that in many cases, the government is revoking and denaturalizing people who are already U.S. citizens. The policy we were discussing that came out on May 21st on adjustment of status, I do just want to quickly chip that in, does not apply to any other type of case except people in the United States applying for green card. It does not apply to people who are applying for green card through consular processing that is from abroad.
Okay.
It does not apply to people who already have a conditional green card, like a 2-year green card, and want to apply for removal of condition. It does not apply to citizenship. Okay? Now, when it comes to citizenship, you have to meet certain statutory requirements under Section 316 and Section 318 of the U.S. Immigration Nationality Act. There are requirements for a person to become citizen. For instance, you must be at least 18 years of age. You must have had your green card for 5 years or 3 years if you are married to a U.S. citizen. You must have lived in the United States, physically present for at least half of those statutory period, that is half of 5 years or half of 3 years. You must also be a person of good moral character. This is where the exercise of favorable discretion comes in again. The officer will look at all your history, including the first time you apply for a visa. Some people applying for citizenship 20 years, 30 years. I have worked on cases where people apply for citizenship 70 years after getting a green card. Last week we had a lady from Australia who reached out to us. She is about 82 years old and she has had a green card for at least 60 years. Because of everything happening now, she finally decided to apply for citizenship. I'll tell you the truth. The government still has the power to go back to the first time she got a green card more than 60 years ago.
So she's been renewing
her green card. So when you apply for citizenship, the immigration officer adjudicating on your citizenship has the power to look at your good moral character and you look at your history as far back as they want to go. Now the guidance is, generally speaking, they should look at your good moral character within the statutory period. That is 3 years if you are married to a citizen, or 5 years if you are applying on the general provision. But when it comes to good moral character, things like your criminal history or your immigration violation or compliance with immigration laws, the officer can go back as far back as they want. The law allows them to do that. So applying for citizenship is no longer, again, just like green card, it's no longer, again, just filling a form. Previously, you could just go on the website and fill out the form and wait to attend your interview, and it's that simple. No more.
No more. Ladies and gentlemen, it's been wonderful time with Attorney Emmanuel Asiriwa. What is your location? What are your social media handles? Is there any contact to reach you in case somebody want to get in touch with you? Are you available anyway? Because you are busy.
Thank you. So our office right here is based in the Woodlands, Texas, in Houston area.
Okay.
But we represent clients all over the world.
Oh, okay.
Now we represent clients in all 50 states of the United States. If you go to my social media handle, you would see my appearance in immigration courts, in USCIS green card interviews, or citizenship in all parts of the country.
Okay.
You can call our office if you want to contact us. The phone number I believe will be on the screen.
Yes.
It is 936-514-2000. That's the phone number to reach out to us.
Let's take it easy. 936.
Yes, 514.
514.
2000.
2000.
Yes.
936 514 2000. Let's take it again. Now,
it's 936 514 2000.
So the zeros are three.
Yeah.
Okay.
Thank you. And you could also follow us on social media, on Instagram. Believe the Instagram handle is @CeriLaw_USA. We're also on YouTube. We put out videos, and we're not typically when you follow our social media, we're not fear mongering. We don't do fear mongering tactics.
Okay.
I'm not going to tell you that the heaven is falling. Just like I told you, the policy USCIS has announced recently has not changed anything, but the way they want to adjudicate these cases. I intentionally make videos to inform the public, both with recent news and some things that you could do, like tips to help your case. And I'm happy to assist anyone like we've been doing. Particularly, it's always close to home when I'm working for people from Ghana, Nigeria, and Africa.
Lawyer, before I leave you, I chanced on a video just yesterday, and a certain attorney like yourself, but she's a female attorney, telling people that, hey, don't go back home. Don't go back home. Even if you have a green card, don't go back home. At this time, don't go back home. If you go back home, hey, anything can happen. Are we supposed to go back home?
Well, if you have a green card approved, you have the right to go to your home country.
Even if I have 2 years?
Even if you have a conditional green card. Now, I would say you should exercise some sort of caution.
Okay.
Speak to an experienced immigration lawyer. If you had a lawyer who represented you for the green card, or you want to speak to an experienced lawyer like myself, contact an experienced immigration lawyer before you travel abroad to speak with them so that they can advise you on what to do and what not to do when you're traveling abroad. But the law has not changed. A lawful permanent resident, whether 10-year green card or a conditional green card, are allowed to go abroad. Virtually all the policies that have been put out there, we can't even count. There's so many policies since Trump came into office. They do not apply to lawful permanent residents. So you should be able to travel abroad. But before you go, especially if you have skeleton in your cupboard, you should speak to an experienced immigration lawyer for advice.
Lawyer, your time is almost up because you have a meeting very soon. But let me ask you, let me chip in with this. I know somebody whose husband filed for the husband 4 years ago, almost 5 years ago, has gone for the interview back home. But if you say abroad, let me correct that. If you say abroad, you mean back home, right?
Yes, I mean outside the
outside the vicinity of America.
Outside the United States.
Okay,
correct.
I have somebody I know whose husband is in abroad. Let me use that word, back home, and has gone for the interview. But for over a period of time, they are still back home. It has been granted, all right, but they are still back home. They've not issued their passports to them. Well, what could that be the cause?
In many cases, those are people who fall under the Presidential Proclamation 10998 that was announced by President Trump on effective January 1st, 2026.
Okay.
The popular 75 countries and 39 countries.
Yes, sir.
People from those countries, if they've attended their interview after January 1st of 2026, regardless that they passed their interview, everything went well, which we have tens of such cases because we represent a lot of people from Ghana, Nigeria, that are part of that ban. They are not, the consular officer is not able to issue the visa to them right now because Section 212F, that's the law that gives the president the power to put a ban on certain immigrants from entering the country. Because of that ban, although a person has attended their interview and everything went well, the consular officer is not able to issue the visa. So in those cases, the consular officer will advise them, congratulations, I'm happy, everything has gone well. Unfortunately, I cannot make a decision because of INA 212F.
Until when?
Until whenever Donald Trump decides to lift the ban. And that can be next 1 year, it can be next 5 years.
So you're gonna keep my passport for that period? I can travel, I can go.
So they do not take the passport. I believe from my clients, the passports are given back to the applicant, and whenever the presidential proclamation, that is in simple words, whenever the ban is over, those successful people will be called to bring their passport to get their visa. Supposing that they continue to meet all the requirements. For instance, a person who is going for an immigrant visa has to attend a medical examination. It's part of the requirement for everyone. And those medical examinations, they expire after 6 months. So what we're likely going to see is that many people would have to redo those medicals again. And those medicals cost a fortune. And they cost a lot of money. So if and when the president decides to lift the ban, none of your documents have expired, or your medical is still good within 6 months, then more than likely you'll be asked to bring your visa, bring your passport to get your visa. But if, say, your passport has expired during the process, or your what do you call it now? Your criminal police certificate. You know, you're required to go through police investigation and bring your police clearance certificate. If your police clearance certificate or any document has expired during the waiting time,
you have to go back and
the consulate will likely advise you to provide those documents. If you're able to provide them, we expect that the visas will be
whoever has gone for those interviews, husband filed for you, wife filed for you, and you've been issued but you've not been given the visa, lawyer is saying that still be in the waiting period. Just keep holding on, and let's pray to God everything will go successfully.
Correct.
Right. Okay. Lawyer, are you expensive? Anyway, that's the last question.
I don't know about that, but we're fairly affordable compared to other firms within our area of practice and our experience. Now, we bring to the table years of experience. And you can go on Google and just type my name and read the reviews. Virtually all our reviews, I think 99% of all our reviews are 5 stars. We also, to answer your question, I don't think we're expensive, but we charge what we think will be fair to us and to the client. And also we have payment plan that allow people to pay in installment. We are financing that allow people to finance their legal fees. Yes.
It's not like a rigid kind of thing. All right, I understand. Anyway, it's been a very beautiful conversation with
Thank you so much, Christian. I appreciate it.
You too. Thank you so much. My listeners are so grateful because there was so much fear in people, and people were asking so many questions.
You don't have to be afraid.
People were afraid. People were. I
have family members who are going through immigration process myself.
Oh, you too?
Yes, I do have family members. I have church members, people who are quite close to me who are going through immigration process. Of course, I'm representing them. And so, when people come to me with their fears, I'm not surprised because I have people close to home who are exercising the same fear. And if I were going through the process, I think it's reasonable to be nervous and to be afraid, but you don't have to be.
Last one. We are done. My mom, my dad has filed for me. Would they still hold on to that, or that one doesn't affect that?
Well, are you referring to the visa ban?
Yes.
It applies to all immigrant visa for people who fall within those 75 countries. So if your country is in that list of 75 countries, immigrant visa particularly. And for the 39 countries, non-immigrant visa, if your country falls under that category, yes, even if your spouse is
your mom,
Barack Obama, you will have to wait.
All right, at this point, everybody's waiting. Lawyer, thank you.
You're welcome. Thank you.
Appreciate you.
Thank you for having me.
Anyway, my name is Christian Opong. It was a conversation about immigration today with Dr. Emmanuel Aseriwa on why...
Attorney.
Oh. I said doctor.
Oh, wait, I take that.
Doctor, professor. Anyway, my name is Christian Opong, and it was a very beautiful conversation with Attorney Emmanuel Aseriwa on immigration fear and the pandemic of people in their hearts, in their various homes and their churches. Why this, why that? And I believe he's been able to clear the air on many questions that people were asking in their various homes. Thank you so much for your time.
Thank you.
Appreciate you, sir.
Appreciate you. Thank you for having me.
Poyaka.